Patentability search or novelty search. In this video, we will cover: what is patentability search or novelty search? The outcome expected from patentability search report. Opinion on patentability. When such a novelty search is not taken. And advantages of a patentability search. Patentability search or novelty search is a comprehensive search performed by the patent attorney to make a judgment about whether the invention is novel and worth proceeding to the drafting and filing stage. Although this is an optional step, there are some advantages of this search which you may like to consider before deciding. The main purpose of this search is to find out if it is worth making the investment for filing a patent application for the invention. In this search, the objective is to find out the closest possible prior art related to our invention. This would help us understand if our invention has novelty. And, when compared to prior arts, it may help us establish non-obviousness as well. The patentability search involves advanced keyword search tactics, classification search, search by company name or assignee, combination of different strategies in a single search query, searching forward and backward reference of a good prior art, search in different patent databases, patent applications that are published, patents that are granted, non-patent literature like articles, blogs, websites, IEEE papers and non-patent literature search, products and services available in market, and other relevant platforms in the domain of your invention. The patentability search is aimed towards finding out the novelty and non-obviousness of your invention. The novelty can be answered quite objectively. If all elements of our invention are found to be present in a single prior art document, then our invention might not be novel. But finding out non-obviousness is a bit tricky. We need to make a judgment whether elements of our invention present in different prior art documents can be combined to arrive at our invention. In simple words, the question is, was it obvious for a person skilled in the art to combine the multiple prior art documents and arrive at our invention? Since the novelty search identifies the closest possible prior arts relating to your invention, by reviewing the results found, an opinion about the patentability of your invention may be provided by the patent attorney. The patentability opinion may be positive, negative, or neutral. In the search report, the results found in the novelty search are closely analyzed and map against the elements of our invention. It really helps if you could identify how your invention is different and improved when we compare it to the results that are cited in the search report. The ideal case would be, some aspects of our invention is solving a long-standing problem that the prior arts failed to solve. This would prove strong evidence for the non-obviousness of our invention. The patentability search report and the opinion provided helps you decide whether to go ahead with the patent or not. Sometimes, what you think is a novel invention might already be patented or known to the public. That is forming a 100% overlapping prior art for our invention. In such a case, a novelty search report saves your time, effort, and cost, helping him decide not to proceed with an invention which anyway would be objected to or could not obtain a patent due to lack of novelty. Cost of patentability search. The professional fees for a patent attorney can range from $500 to $3,000 in the US, and it is in a similar range in other countries and currencies. Time required for patentability search is about 5 to 7 working days. Opinion on patentability. Based on the result of the patentability search, patent attorney gives an opinion about the patentability of your innovative idea. Negative opinion. If there are results in patentability search report which are almost the same as your invention and there is no novelty in your innovative idea compared to existing knowledge, then a patent agent or attorney might advise you not to go for patent filing. This will save you a lot of time and costs that you otherwise would be incurring on filing a patent application for an invention which would not result in a granted patent. Neutral opinion. In this case, the patent agent/attorney is of the opinion that your invention stands a fair chance of getting a patent grant for some aspects of your invention which are found to be novel and having non-obviousness based on results in patentability search. You may receive some objections from the patent office, yet by responding to it, you may get a patent for your invention. Positive opinion. When your invention has some features that are novel and non-obvious when compared with existing knowledge and prior arts found in the patentability report. This is a positive sign, and a patent agent or attorney might advise you to go ahead with patent filing with a positive opinion of Patentability Search. Although having benefits, going for patentability or novelty search is an optional step. You may choose to directly file the patent application without going for a patentability search. Now let's understand when a novelty search is not taken. When you are a business owner, you are going to launch your product or service into the market anyway, and you want patent protection for the invention. You require a patent pending status or patent application number to mention on the product/website for obvious benefits like positive image in the eyes of customers, bankers, channel partners, establishing you as an expert in the industry, and to raise funding, etc. In such case, you may think to skip novelty search and go directly for patent drafting and filing stage. Another scenario would be if you are a student or from an academic institution, and you wish to strengthen your resume with patent application number and ultimately patent granted for your invention, and if you are on a tight budget, then you may want to skip the novelty search and go directly to patent drafting and filing. Advantages of a patentability search. Patentability search helps you in identifying the closest possible prior arts, which are likely to be found by the patent examiner at the examination stage of the patent application. Hence, considering these prior arts before writing a patent application increases the chances of getting a patent granted. The results of the patentability search help patent attorneys to draft better claims, particularly focused on novel parts of the invention. The identified prior arts are often mentioned in the references of patent application, and our invention is established as a solution to a long-standing problem that is not yet solved. Such approach creates good chances of proving non-obviousness, which improves chances of getting a patent granted for our invention. And ultimately, patentability search also saves a lot of unnecessary costs, efforts, and time in going for filing patent application for invention that doesn't stand a chance of surviving patentability criteria and would be rejected anyway. Hence, many inventors sees patentability search or novelty search as an insurance cost, which would save you from expenses of patent filing for an invention that may not be granted due to lack of patentability. Therefore, although an optional step, it is recommended to do patentability search for your invention. Hope you received some value from this video. For more information you may visit patentattorneyworldwide.com. Thank you for your time, take care.